Yes, I'm Jay Wilkinson, and I've been a judge on the Federal Court of Appeals for the Fourth Circuit since 1984. President Reagan appointed me, and I think more importantly, I'm a father of two children, and just had my first grandchild not so long ago. They're all important. The briefs give me an inclination as to how I want to resolve a case. But the oral argument is really critical, and it's good to emphasize the point, because some people say, well, oral argument is just for show, that it's just the judges going through the motion. That they really have their minds made up on the basis of the briefs, and this is all just some kind of this is all ceremonial. And that couldn't be less true. I mean, there are many times when I've changed my mind a little bit or adjusted my mind after oral argument, and one of the things which your good question points out is that you get to hear the views of your colleagues as well as the litigants. So when you're at oral argument, there are a minimum of 4 or 5 different voices coming in on you, informing you, all of them. The colleague on this side, the colleague on that side, this litigant, that litigant. So it's coming in on you from very different directions, and it would be a remarkable thing to say, well, all of this had no effect. I mean, it does most decidedly have an effect. It's an odd thing, because sometimes the attorney who loses gives the best oral argument, gives the best performance, and that's really different from a law school moot court thing where we award the golden ring to the students who make the best argument. Well, when you have a real live case, you know, there may be limits to what even the greatest lawyer can do with a bummer of a case. You can't just work miracles up there. You know, facts are stubborn things, and statutes are stubborn things, and so you get sometimes these lawyers who lose a case, they still contribute enormously to the opinion by informing us, and they make a great contribution to the judicial process. And I've had to resist the temptation, really, to write a little note and a little letter to the losing lawyer and say, you know, you lost this case, but you made a great argument, and it really helped the understanding of the bench, and we really appreciate everything you put into it, and the like. And then I thought, well, you know, that's not going to go very far, because the lawyer's going to what's a lawyer going to say? Is he going to speak to his clients and say, well, John, we lost the case, but the judge thought we did a great job and contributed to the development of the law? And then John says, you mean I got to pay a judgment of such and such amount of dollars? So I've resisted that a little bit but one day I may write that letter. One of these days I may write that letter, because my gratitude to people for their contributions to the process, to helping us come up with a good result, is really immense. Yeah, it's so much impacts on it. You know, I'm sitting there and I'm saying, all right, now, and we sit in panels of 3 in an appellate court, And one of the things I got to do is no single judge on a circuit court can make a decision. You have to get along and rely on your colleagues, and you learn tremendous amount from them. But you have to convince at least one other person, and preferably two, that you're not nuts. And so I'm thinking to myself, okay, I know this colleague pretty well, and he or she emphasized this to me in conference, and I want to make sure I cover that point. And I know this will be of interest to them. So a lot of times the whole product of an appellate court, it's not an individual product. It's a collective judgment. Three people make better judgments than one. That's the judgment Congress made, and it's absolutely sound. So I'm thinking about the person whose vote I need when I write that opinion. And I want to respect where they're coming from. It's really different. When you write a novel, you don't need another vote. And that was one of the things that surprised me when I got on the bench, is that anything I said I need another vote for. I mean, in class, I didn't need another vote for something I was going to say. If I was going to write a newspaper article, I didn't need another vote. Editors perhaps, but I didn't need another vote. But in this job, somebody's got to say, yeah, I agree. And so you need to take them into account. And then you need to take into account certainly the Supreme Court and what its decisions are. And nobody likes to get reversed by the Supreme Court. It's like a spanking. It's not something you want to happen. So, they're my bosses. And you try to please your boss. So that's what you think about. And then another thing you think about, you think about the law as a whole, the precedent of it, the standard of review of it, what went on in the trial court, the finding of fact that the district court made, the text of a provision, the history of a provision. What are the roles of other organs of government? How does Congress play in here? How do the executive branch prerogatives play in here? What's the role of state government? What's the role of the private sector? There are a lot of other actors out there, and so you're just one part of a very intricate piece of social machinery, and you have to respect the competence and the job that other organs of government and other people are meant to do. So there's no magic bullet. I mean, this is not a mechanical exercise. There really isn't a robotic element to it. It's part art and it's part science. But having said all of that to you about all the different things I consider, at the end of the day, there are those litigants in front of you. We hear just lawyers, but behind every lawyer is a real live person. And so, when you get through all the complexity of it and all the legal doctrine and the rest, you still have to say at sundown, how does this impact those people? This is a judgment. It's going to be observed. How does this fall on somebody's life? And you've also got to think, what's the long-range public interest here? Are you doing? You want to consider that individual human being and his or her dignity, but you also have to consider the impact on the society at large, and whether you're damaging a larger social fabric when you resolve a case. This is not an easy job for any of us on the bench, and at the end of the day, you probably say to yourself, well, I did the best I could. I gave it everything I had. No, I mean, I think particularly with litigants, you've got to be strategic. I mean, the adversary process is not I don't like to refer to it as a game. It's much too serious for that. But is there strategic behavior in the course of the litigation process? Absolutely. I mean, people they're practical people, and you want to win. The only thing I can say is that it's very tricky to do it that way, to sort of target this particular person. I mean, it's sometimes just too obvious, and it doesn't look. It doesn't come across in an attractive way when you are just so obviously playing to any one particular individual on a bench. And I'm not speaking just about the Supreme Court. I'm talking about all courts. It is much more, I think, creates a much better impression when somebody approaches the court's jurisprudence as a whole and doesn't sit there and say, well, as you said, Justice so-and-so, or as you said, Judge so-and-so. It's more effective, I think, if you do what we were talking about earlier, which is understanding that courts are collegial bodies, that they make collective decisions, and you treat the corpus, the whole corpus, not as a respectful whole, and not just try to aim your comments at one particular jurist. And I think it creates a better impression for everybody.